Misty Rice, Leonard Williams, Tristan Martin. Thank you, Ms. Thompson. Rosamond Shannon. Mary Hines. Christopher Lapoma. Here? Where? Misty Munn. Ethan Evans. Christopher Hunley. I don't see Mr. Hunley in Zoom. Did we approve that? Okay. Julio Soto. John Lapano. Chad Thomas. Chad Darvin Thomas. Crystal Barnes, that's 130. All right, is there anyone's name who is in the courtroom that I've not called on this morning's docket? Your name, sir? Say again. Mr. Garcia. And your name, sir? John Ford. Yes, and Mr. Ford, you're at 10 a.m., I believe. That's why I didn't call your name. Thank you. You'll do that for me. I appreciate it. All right, counsel, not in a mad rush, but does anyone have anything that's ready and brief? Ms. Thompson, I think Ms. Thompson, you raised your hand first. If y'all want to form a line right over here, I'll take you as you come. Ms. Thompson. Tristan Martin. All right, Mr. Steele, if you'll step out of the way, I need to see Mr. Martin. Mr. White, if you'll move over to the other side so I can see Mr. Martin here. This is CR 2180, State versus Tristan Paul Martin, set for pretrial today. Ms. Thompson, go ahead. All right, court will set Mr. Martin then for a docket call. Do you have your calendar with you, Ms. Thompson?
Yes, go ahead.
Are you available on May 27th?
Yes.
All right, the court sets Mr. Martin then for docket call on Thursday, May 27th. Mr. Martin, after you get your yellow notice of the reset date, then I need you to report to the pretrial release department. There's some paperwork I need you to sign here, conditions of pretrial release on your bond, okay? And they'll give you more information here. Yes, thank you, Ms. Thompson. Mr. Gimbel. Mr. Cohey. CR 2152 set for arraignment today. Have you had an opportunity to go over the indictment with Mr. Cohey?
Yes, I have, Your Honor, and his name is spelled correctly, and all the charges, and entered the plea not guilty.
All right, the court will enter Mr. Cohey's plea of not guilty into the record. We'll set this matter for pretrial. Are you available also on May 27th, Mr. Gimbel?
I visited with Ms. Taylor for June 15th was the next best day.
That's also available. All right, June 15th. All right, court sets Mr. Cohey then for pretrial on June 15th at 9 a.m. Mr. Coe, I'll need you to report to pretrial release also to sign additional paperwork, conditions of pretrial release, Mr. Gimbel. You may want to stick around to speak with him if he has any questions about that.
Will do this.
Thank you, Mr. Gimbel.
Who's collecting me?
You can just set them right here on that. Thank you, sir. I appreciate your help. Mr. Wells, you may.
Rosamond Shannon and the state's going to interview and speak with this investigator. So we just need to reset.
Okay. Mr. Shannon, Rosamond Shannon. Cr2389 set for docket call. It's my understanding that the state wishes to have a reset to conduct an interview. Is that correct?
Yes, Your Honor, they have asked me to meet with a CPS worker to get additional information. I believe they're also going to be forwarding me some medical records and I think 30 days.
All right, you available on June 15th, Mr. Wells? It's a Tuesday.
Yes.
All right, court recess, Mr. Shannon, for an additional docket call on Tuesday, June 15th at 9 a.m. This is also CR2364. Once he signs his notice, once he gets the yellow copy, leave the white copy there, and he is excused. Thank you, sir. Sorry about that. Mr. Baker, Tyler Baker, CR217. Yes, Mr. Ashmore, can you move? It's okay. We're set for pretrial today, I believe.
We have been to the DA's office to put him in U.S. Navy and have time to talk to the recruiter.
Okay, so how about we just set it for docket call, and then if y'all work it out between now and then and dismiss, that'd be fine. All right. This is cause number CR21-7, State versus Tyler James Baker. Are there any contested pretrial motions at this time, Mr. Harden? All right, there being no contested pretrial, court will set this for docket call on June 15th, unless you have any scheduling issues that day. All right, Mr. Baker, once you receive your yellow copy and sign, you'll be free to go. Yes, thank you, Mr. Harden. Your name, sir?
Ben Flory, Your Honor, for David Jackson.
Yes. There we go. Damon Drake Jackson, CR21-22.
We have received discovery and going over it to make it one more business. I have had a chance to evaluate the propriety of the motion. Ask for a reset of the pretrial.
Any objection from the state?
No, Your Honor.
Okay. Court will grant Mr. Jackson an additional pretrial hearing. Are you available on June 15th?
Yes.
All right. We'll set that for June 15th at 9 a.m. The court is going to place conditions of pretrial release on Mr. Jackson. So once he signs and gets his yellow copy, I need him to report to pretrial release through the store. And it's just conditions of bond. He's going to report drug test, no new offenses, those things.
Yeah.
So they'll be able to give you a copy of that over there.
Will do.
All right.
Thank you.
Yes, sir. Nice to meet you, Mr. Ford. Right here in this white basket, you'll just fill that out with cause number and then return the, there you go. And then you'll just return the white copy to me and he'll get the yellow copy.
Thank you.
Mr. Jackson, if you want to step over here and have a seat in this jury box. Are you ready on both McCoy and Watkins? All right. CR 2262, Stormy Ray Watkins. I'm sorry. I just combined your client. I combined your clients. I'm sorry, Mr. Watkins. I took her first name, your last name. Stormy Ray McCoy. All right. I believe that we were here today and state has tendered a motion to dismiss. It's my understanding that Ms. McCoy has paid her delinquencies with the pretrial release department. Court hereby grants the motion to dismiss, and I'm signing that order today. Yes, go ahead. All right, Ms. McCoy, you are free to go. And if you want a copy of this, if you'll have a seat out in the hallway, we can get one to you. All right. That's how efficient I was trying to be today. Mr. Still, a 2-for-1.
Judge, they said that she actually might be able to refund on the money she had. So
I believe that she may, I checked with him yesterday, any monies that she paid in towards indigent attorney fee credits, and you're not court appointed, so there would be some money returned to her, so. Michael Watkins, CR 2201. All right, Mr. Watkins is set for docket call today.
Judge, I think the state and I have already sentenced for a plea. I think the state is also requesting that he submit a new waiver date.
That is correct. We would not oppose the recess.
Okay. All right, so let's do this. I'll recall the case. Mr. Watkins, if you'll just have a seat over here, we'll have the drug test administered, and then pending the results of that, then we'll make a decision on whether or not your case gets reset.
Thank you.
All right, so you're just gonna stick around, Mr. Steele?
Yes, sir. Thank you.
All right. Now, all you have is Mr. Hankins, is that correct?
Yes, sir, Your Honor.
Let me zoom him in. All right, this is cause number CR 20121, State versus Quincy Lamar Hankins. For the record, Mr. Hankins is appearing via Zoom today. Court has this set for a status on the ruling on the motion to suppress. The court, after having reviewed the evidence and entertained the argument of counsel, the court has denied the defendant's motion to suppress evidence. And I believe I signed the order yesterday and had it filed with the clerk, so it should be an e-file.
Yes, sir. We would request the court findings of fact.
And they're included in the order. So what we'll do is we'll set Mr. Hankins then for docket call. Are you available on June 15th?
Yes, sir, Your Honor.
All right. So Mr. Hankins, you'll appear in court in person on June 15th at 9 a.m.
Yes, sir. Thank you.
You're welcome, and you're free to go. I don't know if I missed it. I'll send this to Hankins. Okay. Thank you. Yes, sir. Okay, so just write him in. Richard. He did, okay. So. Mr. Wood, are you ready?
Good, I'm ready. I suppose.
Mr. Thomas here? Check.
I'm ready again.
Let's call him real quick. Chad Darvin Thomas. Chad Darvin Thomas. The court does not show him trying to log into Zoom either. John Lapano, Cr2389 Mr. Lapano is set for docket call today, Mr. Wood.
Discussed on this case, where she just thought we must have gotten scared, ran away, but there is some discovery that hasn't been provided to you yet. She knows about it, includes CPS records, it also includes medical records as well. Obviously, I'd like to have the opportunity to look at all of those things, and then be able to discuss the case in a bit more detail on it before I know whether or not there's any pretrial matters to take up and discuss. I don't believe there's any right now.
Are you available for additional docket call on June 15th?
June 15th.
All right, court will set Mr. Lapano for an additional docket call June 15th at 9 a.m. Yeah, kind of right over here in front of this paper. Thank you. All right, other than Mr. Thomas, is that all you have, Mr. Wood? All right, if Mr. Thomas appears, I was going to let you know that he's delinquent on his pretrial release, about $420 between attorney fees and supervision fees. So keep on coming. Perfect. Yes, thank you, Mr. Wood. Mr. Schmidt. I got the podium on just for you, sir. Just for you. You see that? All the other attorneys, we're gonna put it up when you're done, so. Is there anyone that you're not ready on? William Ivy. This is cause numbers CR19, 313, 314, 315, 316. I believe all cases are finally together on docket call announcement.
Correct. They are in discussions with Ms. Curry about potential resolutions we received we offered recently. And we have a chance to discuss that in detail.
Any objection from the state for additional docket call? June 15th? No, I don't have, I'm out. I had to modify my docket. What about May 27th? All right, Mr. Ivy, we're going to set you for an additional docket call on May 27th at 9 a.m. Yes. Okay, yeah. It'd be in his best interest. All right, Mr. Garcia. You'll just come to the center podium, Mr. Garcia. This is cause number CR20-00079. State versus Daniel Garcia, and we are set for pretrial today, Mr. Schmidt. There being no contested pretrials, court will set this for docket call on May 27th. Is that all you have, sir? All right, Mr. White, Nolan White. Are you ready on all yours?
Yes, sir.
All right, court calls Ethan Evans, CR 2117, CR 2145. Mr. Evans is set for pretrial on the possession case and arraignment on the DWI, I believe.
Yes, sir. We try to get both on the same page. If we could, at this time, on the DWI, Mr. Evans wait for arraignment. We're not going to this time, charged with this person name, the information and it's all correct.
Okay. And are you going to have any contested pretrial motions in your possession case?
I've got it at this point. So I don't. Of course, go ahead and make the vote on docket call.
You think you'll need a pretrial though for the DWI to consider any motions suppressed or anything?
Not this time.
Okay. All right. Court will set Mr. Evans then for docket call. You available on June 15th? We'll set each case for docket call June 15th at 9 a.m. And Mr. White, I'm going to have Mr. Evans sign conditions of pretrial release. So once he signs the notice of appearance, if he'll report to the pretrial release department, they'll go over the paperwork with him. Right. Yes, please. You can just have a seat over here and they'll get to you in just a moment. Did Mr. Hunley arrive?
I believe, my assistant said he was getting code from, he was set for pretrial today. Follow express, was gonna have to put that on that interior docket. He's supposed to be trying to get code from that, but I'm guessing since you're asking that question, he's not in there.
Let's go. Actually, just popped in as we were sitting there speaking. All right. Hearing this is Mr. Evans. He has conditions of pretrial release. While his video is trying to start, we'll move on. Cr2389, Eulalio Soto. Mr. Soto is set for docket call today, Cr2369.
Your Honor, we'll resolve that case. We have to complete it.
All right, I've got either May 27th, or if it's going to be a time offer, we could do June 1st or June 15th.
May 27th.
All right, we'll set Mr. Soto then for plea before the court on May 27th at 9 a.m. I'm going to go ahead, Mr. White, and have him also sign his conditions of pretrial release. He's all right. Excellent. Thank you. Do we have him? Your name, sir? Michael Watkins. It's Mr. Kyle Steele. So he just wants to get drug tested today. If he's negative, then we're gonna send him to the plate for 7 days. Sorry, I didn't know if y'all heard that when you were in here. All right, Mr. Hunley, we're ready for you. All right.
hear me?
Yes, I can see and hear you just fine. All right, this is Cr2389 State versus Christopher Lamar Hunley, and we are set for pretrial today. Go ahead, Mr. White.
Your Honor, I filed a motion to suppress in this matter. I don't anticipate this to be a kind of motion to suppress to take favorably. Just discussing prior coming in here, if there's a possibility of this getting resolved, the issues, then we will do so.
All right, it looks like I did not schedule an evidentiary hearing for May for whatever reason. So the next evidentiary hearing I have would be June 29th. So Mr. Hunley, court's going to set you to appear before the court for evidentiary hearing on June 29th. That'll be at 9 a.m. I'm also going to order you to report to the pretrial department to sign conditions of pretrial release that are going to be attached to your surety bond. In this case, it's going to require you to drug test and report and things of that nature. So today is Tuesday, the 27th. Where do you live, sir?
Waynesboro, Mississippi.
Mississippi. All right. So I'm going to order you to report to the pretrial release department sometime before Monday, next Monday,
Okay.
4 p.m. And let me give you their hours real quick. Monday through what? Tuesday, Wednesday, Thursday. Say that again.
Monday was closed at 7, Tuesday closed at 7, Wednesday, Thursday, 5, Friday.
Open up at 8 each day. All right, Mr. Hunley. So I'm going to give you a couple options here. Mondays and Tuesdays, they were open from 8 a.m. to 7 p.m. And then Wednesday and Thursday, they are open from 8 to 5 p.m. And then Fridays are open from 8 to noon. Okay?
Okay. Yes, sir.
Whatever works in your schedule, you need to pick one of those days. And I would recommend that you call ahead and speak
Yes,
with,
sir.
set up an appointment so they'll know you're coming, since you're having to travel
Yes, sir.
rather than just trying to show up, and then fit it in and make sure that you report before Monday at 4 of next week.
Okay, sir. Thank you.
Well, I'll tell you what, since they're open till 7, I would say Monday before 6. All right.
Okay.
Monday
Yes, sir.
Before 6 p.m. All right. You understand?
Yes, sir.
All right. Can you hear Mr. White?
Yes, sir.
Chris,
Yes, sir.
Stay right in your phone. My office will be contacting you today, okay?
Okay, sir.
Thank you.
All right. You're free to go, Mr. Hunley.
All right. Thank you.
All right, Mr. Stevens, are you ready? Good. Let me see if I can throw you some curveballs here. Brandon Donahue, CR13435. All right, I show Mr. Donahue is set on a status today. If you could refresh my recollection.
Yes, sir. He had not been in court in quite some time. So I guess that's why we put on the status. We do want to set it for a plea.
All right. Can you do the plea on May 27th? All right, Mr. Donahue, the court's going to set you to plea on May 27th. That'll be at 9 a.m. So here's something that you're going to need to address with the state is that Mr. Donahue is about $1,500 delinquent on what he owes the court with regards to attorney fees and bond supervision. In this case, 240 delinquent on bond supervision, 1,200 on attorney fees. Let's see, I don't, what level is this case? Is this a state jail?
It is, sure.
So you know what your fees are going to be. And so he doesn't look like he has any credit towards any of that. So I would just ask that those are taken into account in the plea agreement.
Yes, sir.
Okay. All right. So Mr. Donahue, once you sign your notice of appearance there and you get your yellow copy, I want you to come back here and meet with pretrial release about those delinquencies. Leslie Gibson, Cr2389. Ms. Gibson set for docket call today.
That is correct, Your Honor. Ms. Gibson gave me some information today that I would like to discuss with the state. If you can allow another docket call, I believe that we will perhaps be able to work it out before we get to this position.
All right. So the court shows this, today's our third docket call.
Probably exactly correct.
So I'll reset it, but this will be the final.
Okay.
Next time she comes, it's either she works out the case or she rejects the offers and we set up for trial.
No problem.
We'll set this for final docket call on May 27th.
Is she free to go, Your Honor?
Yes, free to go. Misty Rice, Cr2133. Ms. Rice is set for arraignment today on possession of controlled substance. Go ahead.
If they please the court, will waive brief for the adoption of the set, which is charged with extra consequences. And her name's on it.
All right, court will enter Ms. Rice's plea of not guilty into the record for this charge. We will set this for pretrial hearing on June 15th. Have any scheduling conflicts that day?
No, sir. You mentioned that date to other people, so.
Okay, good, good. Is it hot in here? I'm gonna go kick the air down. It's over here, right by the door. It's gonna teach you to come to court. I don't know, whatever it is, about 2 or 3. Yeah, keep it to where it stays on, yeah, to where it comes on and stays on.
make sure you excuse.
Yes. Thank you. Leonard Williams, CR2372. All right, Mr. Williams is set for pretrial today.
Yes, Your Honor, we have no.
There being no pretrial motions, court will set this for docket call also on June 15th at 9 a.m.
Good morning, Your Honor.
Good morning, Mr. Staub. How are you, sir?
I'm doing okay. How are you?
Doing well, doing well. Let me see if I can find your client here.
I have two. I have Miss Gant and Mr. Duncan, husband and wife.
Okay, I
They
see
should be on the
Miss.
phone together.
Okay, they're on the phone together. I see. So
Yes.
under Miss Gans. All right. All right, Miss Gant, Mr. Duncan, can you see and hear me? It's like they're still connecting.
Yeah, let me text them and make sure. There they go.
All right, Miss Gant, Mr. Duncan, can you see and hear me okay? Looks like.
Are you guys muted?
See if I can send them a message.
I'm gonna text them as well. Oh, there it goes. It's connecting. Your Honor, while they're trying to do that, I don't mind, if you don't mind, if I just tell you what's going on.
Well, let's wait because
Okay.
they can't hear us right now. So I want them to know what you're saying and what I'm saying.
There we go. Now unmute yourself.
There it is.
All right.
All right, Mr. Duncan, Miss Gant, can you see and hear me okay?
Yes, sir.
Okay, and Mr. Staub's present in our hearing as well. If you can't see him, you may have to move left or right on your phone there. All right, this is cause number CR2384, State versus Zachary Perry Duncan, and also CR2386, State versus Jamie Helpies Gant. Go ahead, Mr. Staub.
Your Honor, I'm going to ask for another quick reset for pretrial. As this court may recall, I had a federal hearing that I just got out of yesterday. It was a 3-week long federal trial. I have not had an opportunity to truly sit down with Mr. Gant or Miss Gant and Mr. Duncan. I plan on doing so this week, hopefully. So if I can get a quick reset, just to have time with them. I'm also discussing negotiations with the government right now.
Have you or have you not reviewed the discovery in the case?
I have the PDFs. I have not been able to get the dash cam or the body cam video. I emailed the prosecutor this morning about that issue. It's not allowing, it's showing up on the portal, but it's not allowing me to download it. And I can't review it on the portal either.
Okay. Any objection from state? All right, there being no objection, the court will reset this for an additional pretrial hearing. Are you available on June 15th, Mr. Staub?
Yes, Your Honor.
All right, that's when we'll set it, June 15th at 9 a.m.
May we have permission to do this by Zoom? Mr. Duncan and Miss Gant are living in and from Louisiana.
Any objection from the state?
Yes, Your Honor. I don't mind them hearing every other time, but we would object to them being restricted on Zoom.
Do you object to them appearing via Zoom for the pretrial on June 15th?
Yes, Your Honor. I would ask that the court ask them to report in person.
Okay,
I can't hear the prosecutor, Your Honor.
Miss Heisel, Assistant District Attorney, said that she does have an objection to them appearing via Zoom every time. And so she said that she would ask the court to order them to appear in person on June 15th.
Your Honor, in response, can we have one more opportunity? I believe we can work this out hopefully before June 15th. And if not, we'll set it for a plea the next time where we can work it out. I just, to make them drive several hours for what hopefully would be only a short 15 minutes, doesn't seem just.
So what I'll do is I will grant the request for the defendants to appear via Zoom on June 15th, but I'm going to order them to report to the pretrial release department. Do they have their conditions of pretrial release?
Yes, Your Honor.
I'm going to order them to report. Mr. Duncan, Ms. Gant, do you already have an appointment scheduled with your pretrial release officers? I'm going to ask you to unmute again. Sorry.
Oh, you guys are on mute. And no, I don't think they would have an appointment. We haven't discussed an appointment.
Ms. Burns, can you assist me? Zachary Duncan and Jamie Gant should be on conditions of pretrial release. Will you check that to see, and if they are, to see if there's an appointment for them to appear? Give me just one moment, Mr. Stahl.
Understand. Thank you.
All right, Mr. Stahl.
Yes, Your Honor.
All right, so what I typically do in my court is I place each of the defendants on conditions of pretrial release, have them report, drug test, monitor them, and have that be conditions on their bail. I don't believe that your clients have that, so this may be a good middle ground. I'm going to place them on conditions of pretrial release during the pendency of the case. And so what I'll do is I'll order your clients to appear by 6 p.m. on Monday. That's going to be my calendar here. That's going to be Monday, May 3rd. So anytime between now and Monday, May 3rd before 6 p.m. for conditions of pretrial release.
They have to appear there in Van Zandt?
Correct. Correct.
Is there a way to have an extra week so they can work with their schedule as far as work goes? Because I don't know if they can get off for the next 3 days to be down there by Monday.
Well, they can report anytime up to 6 p.m. So where do they live in Louisiana?
Shreveport.
So you're about 2 hours away?
Yes, sir.
Okay. So there's probably, that's not too far of a distance. So just, I'm going to order you to report to the release department, and I'm going to ask that you call and make an appointment with them. Do you have something to write with?
I do, Your Honor.
Okay. Their number is 903-567-4066. And just ask to speak with the pretrial release department and to schedule an appointment. And they are open Mondays and Tuesdays, 8 to 7, Wednesdays and Thursdays, 8 to 5, and Fridays, 8 to noon.
We will call right now, Your Honor.
Okay, and so we'll just order that they appear before 6 p.m. on, I'll tell you what, I'll extend that to Tuesday, May 4th. So anytime between now and Tuesday, May 4th, 6 p.m.
Yes, Your Honor.
And then I will allow them to appear via Zoom on the 15th. For
Thank
pre.
you, Your Honor.
All right, so do you understand, Mr. Duncan, Ms. Gant?
Yes, sir.
Yes, sir.
Any questions? And Mr. Staub has notes and understands, so you can give him a call, okay?
Thank you, Your Honor.
All right, you're free to go.
Thank you.
Mr. Adams, are you ready? Johnny Ray Harris, CR 1524. All right, Mr. Harris is here on a motion to adjudicate, I believe.
That's right, Your Honor. I visited with Mr. Harrison at the DA's office yesterday. We have not been able to come to a meeting of the minds. And so what we're going to have to do, I think, with the court's indulgence, is to set him for a contested revocation.
And I'm assuming you don't want to do that on Thursday.
I did not want to do that.
All right. As I mentioned before, I do not have a contested evidentiary docket in May, so that's going to push us to June 29th. June 29th, and we'll set that for 9 a.m. So, Mr. Harris, I want you to understand you're still on community supervision. Still have to report, still have to pay. You're still under orders of this court. Just because the motion has been filed doesn't mean that you're free from those obligations. And it's in your best interest to continue to report and do those things, lest those be used against you in an amended motion, okay?
Mr. Harris, for you.
Yes, free to go. Mr. Steele,
I think Mr. Watkins passes.
Burns, do we have an update on the UA for Mr. Watkins? Ms. Burns, do we have an update on Mr. Watkins and his UA? No?
Negative.
Negative for everything? All right, let's recall Mr. Watkins. Sorry, Mr. Adams. You don't have to move. You don't have to move. Hold what you got. This was one we called earlier and I was just waiting on a update. All right, CR 2201, State versus Michael Watkins. Mr. Watkins set for a docket call today. We want to set him for a plea, correct? All right, you want to do that on May 27th or June 15th? All right. And the court's aware that Mr. Watkins has passed his UA test today. So the court sets this for plea on June 15th at 9 a.m. Mr. Watkins, I want you to remain clean between now and then. You understand? All right, it's not a pass it today and go celebrate and then come back to the score. Okay. All right, we'll see you. Has he signed his notice of appearance? Have him sign that, and once he receives the yellow copy, he'll be free to go. And it's over here, Mr. Steele, right there in that basket. All right, I apologize, Mr. Adams. Christopher Quintanilla. This is CR 2131. Mr. Quintanilla set for pretrial.
No, we don't have a pre-trial. I've received a plea offer from the DA's office recently. I tried contacting Mr. Quintanilla yesterday afternoon, but we missed each other. And honestly, I'm a little behind on things. I was in a jury trial in Hartford County last week, so I'm still digging out. What I'd like to do is set this for a docket call. I think we can.
No contested pretrials.
No contested pre-trial this time.
All right, court will set Mr. Quintanilla then for docket call on, are you available on June 15th? Also have May 27th.
May 27th.
All right, we'll set Mr. Quintanilla then for docket call on Thursday, May 27th. It's not. We only reviewed that thing 9 times. Oh yeah, it's good to go. And we left off docket calls. We usually do it under other, yes, that's going to be a revision for version 2.0. Just lay it right there on that desk. KD Resky, CR16267. Okay.
Excuse me. The state guy worked out yesterday. We don't have paperwork ready this morning. However, such short notice. And it's going to be a resolution that's going to be on proof of truth time. So to set this for the hearing.
I do have a jail only docket on June 1st in the afternoon. That'd be a Tuesday. I could also bring her in, depends on how much time you need, and we can get her in before then. We could do May 11th.
First,
June 1st.
yes, sir.
And I mean, we can do it before then. Okay. All right. We'll set Miss Risky then to plea June 1st, and that'll be at 1:30. And Miss Risky, you'll report out at the Justice Center, out at the jail. Okay. Jessica Sotelo, CR20410. All right, Mr. Sotelo is set for docket call today.
I just got a plea offer from the DA's office. Within the last several days. Tried to call this I need to visit with her about this. So with course of all, I think we're gonna have this worked out. I'd like to get it reset. This is our first docket call.
There being no objection from the state, May 27th. Yes, sir. All right, so Mr. Sotelo, the court's going to grant an additional docket call, May 27th at 9 a.m. Mr. Adams is going to bring you a form. When you sign that, when you receive the yellow copy, you'll be free to go. State, are y'all still working on the paperwork for Judge Brabham and Mr. Ford? If Mr. Sanders is ready and the paperwork's good to go, then I'm going to get Judge Brabham in and let him do his business. make sure. Okay. Okay. Judge Brabham, they said they're working on some other issues with the paperwork. And they said they hope to have it done shortly. All right, Tristan Kimmerling, CR 2293. I have a note that he's been verified in Wood County Jail.
Yes, Your Honor, that's where he was last time.
I believe we verified him yesterday. So let's just set him for another Wood County custody status. And we'll just set that on. I've got you coming back on that June 1st date, right? I think. Yes, afternoon only. Well, okay, let's don't do that then, because he could be out. We'll just set that on May 27th. All right, is that everyone you have, Mr. Adams? You, oh, yes, Kofer. Rochelle Kofer, CR 2285 320. Docket call.
Your Honor, statement, again, talking about the resolution from Mr. Hofer, in our yesterday, there was an issue regarding in federal case sometime.
It was all, we're speaking with the federal district court in Dallas area about the potential prior that might assist in our resolution.
Due to federal issues, due to the, so I'd like to reset for those obligations, to sort through those details to see if we can get it done.
It's not a pending case. You're talking about it's a prior.
It's a prior.
It's something that you're wanting to use for punishment potentially.
You're right.
Okay. And I believe your client raised her hand. So in just a moment, I'm going to let you speak with Mr. Adams. Ms. Kofer, okay? Go ahead, Mr. Adams, and see what she raised her hand. All right, there's no objection. It's actually the state's request. You're joining in the request.
I would go ahead and ask them to reset so we can try to get that.
All right, we're going to reset Ms. Kofer then for an additional docket call on May 27th. And that'll be also at 9 a.m. He's coming back to you in just a moment, so he's going to have you sign a form.
Your Honor, this Kofer was Lancaster. She's been in our transportation with our
No, my criminal dockets are Tuesdays and Thursdays. My civil dockets are Mondays, Wednesdays, and Fridays. So
would it be possible for her to attend the next one?
does she have that capability? I would say unfortunately not, because it's our second docket call. So I'd be looking for an announcement of resolution on that day. So if it were pretrial, I would say yes, but docket call, unfortunately, I'm gonna say no. All right, does that complete the docket for you, Mr. Adams? For the morning, excellent. Mr. Manning? You ready? You're ready on Mr. Rosa and Raina? All right, do you know if Mr. Christopher Morgan ever appeared?
At this time, I have not seen him.
Okay.
I've actually voted for recently, so.
Mr. Rosa? This is CR2409 Calixto Rosa set for pretrial.
Yes, Judge. We're gonna ask for another pretrial. We're still missing some evidence that is part of some of these other cases that would be impactful in this case. However, we have received a new offer today that will resolve all three of these cases. We have some time to consider that offer and to get discovery review for that offer, as well as we have additional discovery.
Any objection to the additional pretrial? You available May 27th?
Yes, Judge.
All right, we'll set Mr. Rosa then for an additional pretrial on May 27th. That'll be at 9 a.m. All right, you're free to go, sir. Thank you. Albert Reyna, CR2132.
Judge, we are set for pre-trial today. We don't have any just pre-trial issues at this point. I'm going to request setting up docket call.
There being no pretrial motions, court sets Mr. Reyna then for docket call on May 27th at 9 a.m. And Mr. Reyna will need to sign conditions of pretrial release today with the pretrial release department. Once he receives his yellow copy, then Mr. Reyna, come have a seat over here and they'll speak with you more about the next steps, okay? All right, Mr. Manning. So you said you're going to try to reach out and speak with your other client, see if he's. Okay, just let me know. All right, Mr. King, are you available?
Yes, Your Honor, I'm
All
available.
right, here we go. I'm gonna get you.
Apologize, Your Honor.
No problem. I'll get you to start your video too right there. I sent you a prompt. There we go. All right, Mr. Chaparro. Slide over just a second. All right, this is cause number CR 21-11, 12, and 13, State versus Francisco Lorenzo Chaparro. And it looks like we're set for pretrial in each one of these. Mr. King, go ahead.
Your Honor, if it please the court, we finally got discovery opened up last week. No fault of the state, completely my fault. Just had some technical difficulties trying to operate the new system that I wasn't familiar with. Kept thinking they were sending me an email link and they were sending me stuff, but it was my fault. Finally got that open with the help of the DA staff and resolved the issues. I haven't had complete time to go through all the discovery in these matters. We would ask for an additional pretrial if it please the court, and then we're ready to go forward.
Any objection from the state?
No, sir.
All right, there being no objection from the state, court will set Mr. Chaparro then for an additional pretrial. Do you have your calendar handy, Mr. King?
Yes, Your Honor.
Are you available on May 27th?
Yes, Your Honor.
All right, court will set Mr. Chaparro then 9 a.m. on Thursday, May 27th for pretrial.
Thank you, Your Honor.
So what I'm going to do is I'm going to have your client sign an appearance form, and I'm going to give him a copy of it. And then I'm also going to have him report to the pretrial release department where the court is assigning conditions of pretrial release. You got to report drug tests, things of that nature. Okay.
Yes, Your Honor. No problem.
All right. So thank you, Mr. King. You're free to go. I'm gonna have your client sign that and then he'll be free to go.
Thank you, Judge.
Thank you. Have a good day.
Yes, sir.
Rachel, will you do me a favor? Oh, actually, let's see. I've got one right here. Give me a stick. All right, Mr. Chaparro, we'll have this form brought to you. You're going to sign here at the X. It's just going to say what today's date is and that you're going to appear again on May 27th. Okay. We're going to give you the yellow copy, and then after that, I want you to report to the pretrial release department. All right, Mr. Ashmore, are you ready?
I am Judge, unfortunately. Rules, James is no show. Not there to reach him, although we did speak yesterday.
All right, I'm gonna call I'll call Miss Fowler. Grace Fowler, CR 2333, 3334, or 333, 334. Believe that we're set for docket call in each case.
Yes, Judge, we're asking for a reset because we're still in negotiation. There's an offer of 40 TDC. We have asked the state, and as I understand, the state has agreed to allow us, if the court will allow an additional hearing so that we can continue to negotiate. We'll do a short reset.
Okay, let me look at our case real quick. No objection from the state?
No objection.
I'll tell you what we'll do. If Miss Fowler passes a drug test today, then I'll grant that request.
Thanks.
So-
She would like to go. She's taking her blood pressure meds and waiting on.
So what I'm gonna do is I'm gonna have you come over here, have a seat. We're gonna administer a drug test. If you pass that, then I will pass your case to, what date do you want, Mr. Ashmore? May 27th or June 15th?
Rather go 27, the judge on set for a trial in Rockwell County. It's a bench trial, so we'll go. I'll request you June 15th. That's all right.
What about May 25th? When does your jury trial start?
It's a bench trial.
Bench
My
trial.
jury Trial starts Monday. You'll have enough of me next week that you won't receive me until June 5th. May 25 works.
Is that better?
Yes, sir.
All right, so tentatively, what we'll do is either way, we'll set Miss Fowler for docket call on May 25th. So whether she's in custody or out of custody will depend on this drug test.
Yes, sir.
Matthew Gould. All right, this is Cr2389 set for pretrial.
Yes, Judge, we don't anticipate any contested pretrial motions at this time. The state and I are still working on our plea negotiations. We do have an offer of 10 deferred. We're asking the court for a recess of the docket, simply so we can continue to work on that. And I understand the state has no opposition.
All right, court will set Mr. Gould in for docket call on May 25th at 9 a.m. Mr. Gould, so he's going to bring you this form. He's going to give you the yellow copy, and there's one other matter I need you to do for me. I'm going to hand Mr. Ashmore this order that I've signed. It's called a TRN processing order. What this is it's an order for the sheriff's office to get your fingerprints so that they can report them to the state. What that means for you is I want you to take this form and I want you to go to the Justice Center as soon as you leave court today. Show it to them, tell them that you need to process in just for your fingerprints. They're not going to change you out. They're not going to hold you. They're going to simply bring you back, take your fingerprints so that it can be reported to the state so that they can comply with state law. This means to me that you were arrested outside of Van Zant County and they don't have your identification records in county. All right. So I want you to go as soon as you get done, just go out to the sheriff's office, show them this form and tell them that the judge sent you over here and they'll process you in and out. And in my order, it says that they're to do it as quickly as possible to not disrupt your liberty. Okay. All right. Yes. Okay. She's going to make a copy for you.
He may be excused after that.
Yes, Mr. Gold. She'll bring you that copy. And then after that, you're free to go.
That's it for me, but I'm going to ask the board if I can step out, try to call Mr. Yates one last time.
Yes,
He did
please.
speak yesterday.
Yes, please. Are we close to being ready on Mr. Ford for Judge Brattle?
Judge, I believe there was
Mr. Elliott, any updates? To court or Mexico or where?
Two people within the house.
Okay.
I was one of
You're one of those two people. You see, oh, I was calling you. Have you seen Mr. Knoll? Ms. Abraham, can you also see if we can confirm whether or not Ms. McCreary is still in Kaufman County for Paul Johnson? Mr. Riddle, it's okay, stay where you're at. Your attorney's not here yet, so I'm looking into that to find out where he is. As soon as he gets here, I'll call your case, okay? And Mr. Sanders' clients, Mr. Howell. Is Mr. Vance here? It's okay, have a seat. Is Mr. Vance here, Terry Vance? All right, Mr. Sanders is working on another issue, and so as soon as he's ready, I'll call your case as well, okay? Whose name have I not called? Cindy who? And- Okay. All right, and so Mr. LaPoma, same thing. All right, so we're just waiting on Mr. White. As soon as he's in the courtroom, I'll call your cases. Is there anyone else?
Okay.
So
Here's the highlighted stuff right here. But I'll get you one.
Yeah, I kind of need a file for this one. So.
All right, bear with me, counsel. They're going to bring me a file, so.
No problem with that.
Okay. Comfort for me. All right, counsel, I have before me two cases. Cause number CR. These are new filings, is that correct, counsel? Are these informations or are these indictments?
No, Your Honor, this is indictment. Let me present the paperwork to you, that may help. Just to refresh your memory, refresh your record, Your Honor, these are cases that went to trial in late 2019. One of the cases ended in acquittal. That's not before us now, but we do have some paperwork just to house clean on that one. But what's before you today are the two remaining cases that resulted in a mistrial via jury. We have reached a plea agreement in each of these clauses for a lesser included offense.
All right. Well, let me see if I can get us on the record in the correct case. We have CR 1600642. I have CR 1800309. State of Texas versus John Aaron Ford. What says the state?
Your Honor, states right here.
And what says the defendant?
Defendant's right.
Mr. Ford, I have two files before me. Counsel, we proceeding under these original cause numbers, but lesser included charges?
That's correct, Your Honor.
All right, thank you. In CR 00642, we are proceeding under injury to a child that resulted in bodily injury. Is that correct, counsel?
Yes, Your Honor.
Do you understand what you're charged with in that case? In CR 1800309, you're charged with, we're proceeding under injury to a child with bodily injury. Do you understand what you're charged with in that case? And counsel, these are the original indictments in the case. Is that correct?
No, Your Honor. I believe the original indictments were robberies. I believe was for, I believe one of them was for continuous sexual assault of a child. And then they were both for continuous. But we are proceeding with the lesser included injury to a child in both cases, and that's why the judgment reflects that.
But the lesser included of the original indictment.
Correct, Your Honor.
That's
Yes.
the point.
Sorry.
Okay, that's all right. So, Mr. Ford, we're proceeding under lesser included counts of both original indictments. Do you understand that? And if you talk to your attorney about that. How do you wish to plead to these lesser included charges in each indictment? Before I can receive your guilty plea, I do need to ask you a series of questions. Please listen very carefully. Of course, counsel, Mr. Ford, we've had a jury trial in this matter. You understand that? If you wish, you could continue to assert your right to have a jury trial in this case. Did you understand that?
Yes.
Do you now wish to have a jury trial in these cases? You have signed several documents in both cases this morning. Is that correct?
Yes.
These are important papers. They tell me that you made a decision to plead guilty in each case. You understand you're giving up your right to many important rights that you have, including the right to have a jury trial. Do you understand that?
Yes.
And there are other important rights that you waived as a result of signing all these papers. Is that correct?
Yes.
Did you sit down with your attorney, Mr. Sanders, and did he go over all these documents in each case? Did you understand everything you signed?
Yes.
Did you have the time to ask him questions if you had questions?
Yes.
And of course, this case has been going on Several years now, is that correct? And I believe Mr. Sanders has been your attorney all the way through, is that correct?
The majority of it.
For several years? Okay. Mr. Ford, has anybody forced you to enter your guilty pleas to these charges?
No, sir.
Who made the decision to plead guilty? And are you guilty of these lesser included offenses? How old are you, Mr. Ford? How far did you go in your school?
Some college.
Do you understand what you're doing in court here today?
Yes, sir.
Tell me what you're doing in court here today.
Pleading guilty to charges that were put forward, so that I can go on probation.
You understand they're lesser included charges.
Yes, sir.
Mr. Sanders, I know you've been in the case a long time. Talk to me about your judgment as to your client's mental competency.
Judge, I believe he is competent. He understands what the plea offer is, the plea agreement is, and that we reduced the third degree felony to a child. He understands the agreement is for probation. And we've gone over the conditions of probation. He understands all that. He understands that as part of this agreement, there's no requirement for extended registration. And I think he understands all the terms that he'd be required to complete. I think he understands the rights he is waiting to plead guilty on this case.
All right. Mr. Ford, did you hear all that? Did you understand that? And you agree with what your attorney said? So there is a plea agreement in the case, in each case. Is that correct? As I understand it, counsel, would you state the plea agreement? Let's see, is it 10 years, suspended for 6 years and a $1,500 fine?
Correct, in each case, Your Honor. And then additionally, there are some court costs and reimbursement fees that are associated on top of the fine. And then in one case, there is a $100 restitution, and that is for the ankle monitor. Mr. Ford has been on pretrial release with the ankle monitor for 7 years now. We are going to agree to this plea agreement, which results in probation, but we are going to agree to lift that ankle monitor since he has had 0 violations in 7 years. So that would result in what would essentially be probation for 13 years in this cause, Your Honor.
Yes. So plea agreement is 10 years, probated for 6, $1,500 fine in each case, and the terms and conditions you've alluded to. Is that correct?
Yes, Your Honor.
Is that your understanding, Mr. Sanders?
Yes.
Mr. Ford, did you hear that?
Yes, sir.
Is that your understanding of the plea agreement?
It is.
Do you understand if I follow that plea agreement, then you must accept each sentence and you cannot appeal these cases? Did you understand that?
I do.
And because it's injury to a child, there is no requirement of sex offender registration.
Correct, Your Honor.
And you understand that also, Mr. Ford?
Yes, sir.
Mr. Ford, have you understood everything we talked about? You have any questions of the court?
No, sir.
Understanding everything we've discussed, you still want to plead guilty in each of these cases to the lesser included offense, injury to a child with bodily injury,
Yes, sir.
which is a 3rd degree felony.
Yes, sir.
Counsel, have I covered all the admonitions, do you believe?
I believe so, Your Honor.
Mr. Sanders, you think we covered everything?
Yes, sir.
All right, Mr. Ford, I'm going to receive each guilty plea. I'm going to make a finding that you make each plea freely, voluntarily. No one forced you to plead guilty, that you are mentally competent. I'm going to allow the state to come forward with the evidence at this time.
Thank you, Your Honor. The state at this time will present the stipulation of evidence and judicial confession for you in each cause.
All right, all those exhibits are received into evidence.
And then at this time, Your Honor, the state will present to you the victim impact statement. And I do believe, Judge, just for the court's information, that at least one of the child victims are watching the online via YouTube.
All right. And is the statement in the sealed envelope? All right, thank you. And just for the record, this is the same case the court tried before a jury with a lot of testimony
Yes, Your Honor.
a year and a half ago, or can't even remember when it was. Latter part of 2019. All right. All right, let the record reflect, I have read and reviewed the victim impact statement. Counsel, did you mention some restitution in the case or not?
Yes, Your Honor, in one of the cases, it's restitution to the monitoring company. There is no restitution to the victims in our plea agreement.
And I take it you counsel with the victim. I mean, she is requesting, have you read the victim impact
I
statement?
have read it, Your Honor. At this time, no restitution is being requested from the victims.
Did you talk to her after she made this statement?
Yes, Your Honor.
Because she had requested it in the statement.
She had requested that, the victim impact statement was returned to us several years ago and before the first trial, Your Honor. The victims have all been notified of this plea agreement.
And they understand there'll be no restitution to them.
Yes, Your Honor.
Okay, thank you. All right, I have read and reviewed the victim impact statement, and does it just remain in the file then, counsel?
Judge, if I could get you to sign the tracking sheet, and then that will return back to the district attorney's office, and we will forward it to the probation department, who will hold it back.
All right. All right, I've signed the tracking statement. I'll return this to you at this time, counsel.
Thank you, Your Honor.
All right.
And state address and close as to the.
All right, Mr. Ford, in cause number CR 1600642, based upon your guilty plea, based upon the evidence, I am going to find you guilty of the lesser included charge of injury to a child with bodily injury. I'm going to follow the plea agreement and assess 10 years confinement, institutional division, Texas Department of Criminal Justice. However, I'm going to probate that, place you on a 6-year probated sentence. You will pay a $1,500 fine. You will comply with all of the terms and conditions of probation, both as stated on the record and all the other standard terms and conditions of probation as set out by law. In cause number CR 1800309, based upon your guilty plea, based upon the evidence, I am going to find you guilty of the lesser included offense of injury to a child with bodily injury. I will follow the plea agreement in that case also and assess a 10-year sentence, probated for 6 years, a fine of $1,500, standard terms and conditions of probation, and all the other terms that were stated on the record. The two cases will run concurrent with each other, that is at the same time. And because I have followed each plea agreement, you do not have the right to appeal these cases. Anything further from either side?
Judge, not on these causes, but we do have a little bit of housekeeping on the case that resulted in acquittal. Judge, on our review of the record, it does not show that we ever had a judgment of acquittal signed. Additionally, in that cause, the state filed a motion to amend the indictment, which was granted, and it was written on the docket sheet that it was granted, but we didn't have the official paperwork signed.
Okay. Well, I'll sign those orders at this time as housekeeping matters. All right, anything else to put on the record before I sign all the orders here at council from either side? All right, Mr. Ford, I wish you good luck. Hope you can successfully complete the probations. If you'll continue what you've been doing for, I believe, 7 years now, you should complete these probations, okay? We're in recess. Thank you very much. Does he make docket entries or just let the clerk do it now? Chris, do you make docket entries? now? Just let the clerk do it.
No. I believe in my system. So if you want to, you just write it on there. I'll type it in. If you want to just write it on the docket sheet.
I'll just. Docket entries, is that all right?
Yeah.
Yeah. Okay, thank you. All right, I've signed all the paperwork. Who does this go to? Okay. Okay, that's it. Thank you.
All right, Mr. Manning, ready? Christopher Morgan, CR 2403. Mr. Morgan, called your case at 9 o'clock. You weren't here, just at that podium back there. Called your case at 9 a.m. You were not here, so I wrote a note, issue a warrant, put Mr. Morgan back in jail. Why should I not do that right now? Well, that's right. But you know where I was at 9 a.m.? I was here. You know why I was supposed to be here? Because I told you I was going to be here. And I told you you were going to be here. And you weren't here. Why not? It's not good enough. Sorry, it's not good enough. So, because your attorney has asked me to give him time to get you here, that's why I'm hearing your case. All right, so you can thank Mr. Manning for that. All right. Mr. Manning, Mr. Morgan set for pretrial.
Yes, Judge, we're going to proceed with docket call. We request that we set up 527.
All right, court will set Mr. Morgan then for docket call on 5/27 at 9 a.m. Once you sign this form and you get your yellow form, Mr. Morgan, I want you to have a seat over here in the jury box so you can sign your conditions of pretrial release. So, yeah.
Send Mr. Randy.
Yeah, I'm still thinking on Mr. Rain. Give me just a little bit more on that. Mr. Schmidt, are you ready? Mr. Manning, will you step through there and let them know that Mr. Morgan needs to sign his conditions of pretrial release?
Yes, Judge.
Christopher Mata, CR 20261. Mr. Mata, same thing. What's the deal?
I work late last night, you know, like 3.
Well, and I'm supposed to, it's supposed to make a difference to me that you didn't get home late till 3. I mean, we knew a long time ago you were supposed to be here at 9 o'clock. Why did you make a decision to stay out till 3 a.m. in the morning?
I clean up parking lots, won't power out late when I have kids. About 3. Basically, my car, I didn't turn my phone back on. So
Well, I'm going to tell you the same thing that I told Mr. Morgan. If it were not for your attorney being here and advocating for you and asking for second chances, you wouldn't be getting one. Mr. Schmidt, Mr. Mata set for pretrial.
Correct, Judge. We don't have a contested pretrial. That's-
All right, court will set Mr. Mata for docket call on 5/27. Yes, thank you, Mr. Schmidt. And Mr. Schmidt, will you approach?
Yes, sir.
Mr. Knoll, he indicates that he had a vacation letter in for this week. So he also indicated that he has no contested pretrial motions. So the court's going to go ahead and move your case to a docket call. So I'm going to fill out a notice of appearance form for you to sign, and I'm going to reset you to June 15th. So what that means, Mr. Riddle, is that Mr. Knowles indicated to the court that he's not asking for any contested motions to suppress or motion to quash. So that means that we're going to go ahead and we'll set you for a docket call. And on docket call, that means the court's going to be looking for some kind of announcement between you and the state as to whether or not the state's going to dismiss the case, you are going to plea bargain the case, or you're going to ask for a bench trial or a jury trial. So that's what we're doing here today. Okay, so I'm gonna get this form handed to you. I need you to sign on that X, and we're gonna give you a copy, Bailiff, if you'll assist. He'll just sign right there on that X, and we'll rip them apart and give him the yellow copy. All right, and so Mr. Riddle also needs you to report to the pretrial release department, and they're going to discuss with you your conditions and reporting, okay? This is Jay Riddle. Thank you, sir. Appreciate you. All right, Mr. Elliott, are you ready? CR 20120, State versus Stephen Paul Gandy. We're set for plea today. Do we have plea paperwork? Thank you. All right, Mr. Gandy. Worried this morning. 9 o'clock came, 9 o'clock went. Same thing I talked to Mr. Morgan and the other guy about. You're supposed to be here when you're supposed to be here. Mr. Elliott was here. I was here. There's part of me that wants to say, no, I'm not going to take this and just let you go to trial and let you face 2 to 20. I'm just being honest with you. What do you want me to do? Do you want me to let you do your agreement that you've reached with the state? Tell me why. Why should I do that? It's 11, almost 11:30. You're almost 2.5 hours late. Tell me why I should not just say, you know what, this Mr. Gandy's not taking this serious. I'm gonna tell you the same thing that I told the other defendants. You better be thankful that you have the attorney you have. Because Mr. Elliott was here and he asked me not to find your bond insufficient, to not issue a warrant, to not just throw you off the docket and throw you in jail and drag you back to court. He asked me not to do that. He asked me to give you time. So this is the man you have to thank. I want you to raise your right hand. I'm going to place you under oath. Stephen, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Put your hand down. Mr. Gandy, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Joel Elliott. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all of your legal questions answered? You understand everything that you've read and signed today? Have any questions before we go forward? Mr. Elliott, do you believe your client to be competent today?
Yes, Your Honor.
You've explained to him his legal and constitutional rights?
Yes, Your Honor.
Mr. Gandy, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams. Range of punishment is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 20 years, and a fine not to exceed $10,000. Do you understand that full range of punishment? The court finds that the proposed agreement between you and the state is that you're going to plead guilty to that offense in exchange for their recommendation to the court that your sentence be 3 years confinement in TDC with a $2,000 fine, $180 restitution, $290 court cost, $55 reimbursement fee, with you receiving 43 days credit towards your sentence for the time that you've spent in jail. Is that your understanding of the plea agreement? Mr. Elliott, yours as well?
Yes, Your Honor.
All right, Mr. Gandy, then to that charge, how do you plead? Guilty or not guilty? And Mr. Gandy, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Mr. Elliott, any objections to states 1? States 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state? Yes. We'll be off the record. Anything for, on behalf of the defendant, Mr. Elliott? I'm gonna take a moment. I'm gonna review the evidence. All right, based on the court's review of the evidence, I do find there is sufficient evidence to support a conviction. Court hereby follows the plea agreement between Mr. Stephen Paul Gandy and the state of Texas. Court convicts Mr. Gandy of the second-degree felony offense of possession of controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams. Court assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice. Court assesses a $2,000 fine, $290 court cost, $180 restitution, and orders him to pay $55 reimbursement fee. Court awards Mr. Gandy 43 days credit for the time that he has spent in jail, and this costs towards his sentence. Mr. Gandy, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward here to the table to be fingerprinted, after which you'll be taken into custody. Sure, if you will. Or you can do it. I don't care whatever you do. Bailiff, what do you want to do, Rachel? Yes, thanks, Mr. Elliott.
No, just a sec.
All right, Ms. Heisel, or whoever made the announcement on Mr. Manning's client, we all approach. Put your hand down. All right, Mr. Howell, you are Denny Thurman Howell III, is that correct? And Mr. Howell, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? You're represented by your attorney, Mr. Sanders. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all of your legal questions answered? Anything about the paperwork today that you've read and signed that you do not understand? Mr. Sanders, do you believe your client to be competent today, and have you explained to him his legal and constitutional rights? All right, Mr. Howell, you are charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. But it appears that the plea agreement you've reached with the state is that you would be pleading guilty to a lesser included Class C assault of family violence, in which you would receive, upon the state's recommendation, a $500 fine. You'd also be ordered to reimburse Van Zandt County $750. Is that your understanding of the plea agreement? Are there no court costs with a Class C misdemeanor?
I think on the Class C, I think that.
I don't know if that doesn't.
The agreement may have been to find court costs combined to be that, but it should still be separated from the judgment, and not just the same.
Go ahead and have a seat, Mr. Howell. We're going to call your case up in just a minute. There's an issue with the paperwork. Yes. Mr. White, are you ready? Mr. Sanders, that's all you have left, correct? And Mr. Vance is not here, right? Terry Glenn Vance?
That's right. I have the phone number I had, I think make contact several times. And I believe the bondsman had also made several attempts and had any success.
All right, I'll send out a search party. All right, Mr. White. Mr. LaPoma? Cr2389 set for pretrial today, Mr. White?
We experienced tested pretrial. See, we said formula is wasted.
Are you available on June 15th?
That would be perfect.
All right, we'll set Mr. LaPoma then for docket call on June 15th. All right, Mr. LaPoma, you're free to go. We'll see you back on June 15th. Misty Munn, Cr2350. It's Miss Munn, a plea. Yeah, I hear you're a month early. Yeah, she was set on May 27th. It's okay, we'll get her in.
Okay.
All right, Miss Munn, if you'll raise your right hand. Ms. Munn, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. Munn, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeffrey White. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all of your questions answered? Is there anything about the paperwork that you've read and signed and reviewed with Mr. White today that you do not understand? Mr. White, do you believe Ms. Munn to be competent today? And you've explained to her her legal and constitutional rights? All right, Ms. Munn, you were charged by indictment with a third-degree felony offense of driving while intoxicated, a third offense or more. The range of punishment for this offense is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you understand that range of punishment? Yes, sir. That means that if the court were to approve this plea agreement today, wherein you would be pleading guilty to the offense in exchange for the state's recommendation that your sentence be assessed at 10 years in the Texas Department of Criminal Justice, but suspended for 5 years community supervision. What that means is that the court could, upon a subsequent showing of a violation of your conditions of community supervision, after a hearing on that matter, could revoke your community supervision and put you in prison up to 10 years. You understand that? Yes, sir. And really, the court could do anything between 2 and 10. So understanding that, how do you charge, or how do you plead to that third-degree felony charge of driving while intoxicated, third or more? And Ms. Munn, are you pleading guilty to that offense because you are guilty of that offense and for no other reason? Has anyone threatened you or forced you or made you feel like you had to plead guilty? All right, the court will accept Ms. Munn's plea of guilt at this time. Is there any objection to State's Exhibit 1, Mr. White? No. All right, State's Exhibit 1 is admitted into evidence, and the court takes judicial notice of Ms. Munn's judicial confession. Is there anything further from the state, from the defense? All right, based on the court's review of the evidence, I do find that there is sufficient evidence to convict Ms. Munn of this offense. Court will follow the plea agreement. Court hereby finds Ms. Munn guilty of the third-degree felony offense of driving while intoxicated, third or more. Court assesses punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place Ms. Munn on community supervision for a period of 5 years. The court assesses a $2,500 fine, orders her to pay $35 reimbursement fee and $290 court costs. I do have a question, though. Is there not a minimum jail time condition of community supervision on a driving while intoxicated third? I think, so the first is minimum 72 hour, consecutive 72 hours. I think for a third, it's,
6, and then I think it's 30.
Judge, I believe the issue is being brought to my attention that there needs to be 10 days. Is that correct?
yes, according to Code of Criminal Procedure 42A401, not less than 10 days confinement in the county jail if the defendant was punished under 4909B, which this is. Yeah, so there's got to be 10 days confinement in the county jail. Does she have any? She probably has some credit for some.
Judge, let me investigate. Hopefully we can find 10 days.
And if not, then we're gonna need to amend to have a special order and we can let her serve it on the weekends. So I'm gonna give this back to you and then recall your case in just a moment. Mr. Woodwhite, I may have stuck my docket to the bottom of your stack there. Good. Can you come up here and finish this? We found that. Go to early
I'm
lunch.
not sure the defense department is super happy about that.
I go to early lunch. I think you could just modify the conditions of community supervision. And we'll do a special order. That way you don't have to change all the plea. I think that'd be fine. I'd be fine with that. Mr. Sanders, are you waiting on me?
Yes, I'm not sure. I need to see check. Like, as far as what he found out about the,
Judge, the clerk is working on
Oh.
the cost right now.
Okay.
The clerk is wavering between what possible.
Well, there's always court costs, because there's always a court.
She has 2 days.
What about Miss Kane? We'll do Miss Kane while we're waiting on the paperwork. Cynthia Kane, CR 20282. You have to write this one on the docket. CR 20-00282, Cynthia Kane. She was actually set for May 27th.
Judge, there is a different impact statement on this, considering it's pled down. I don't know if you want to consider it, but we'd want to provide it regardless.
All right, Ms. Kane, if you'll raise your right hand. Ms. Kane, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Are you Cynthia Sizemore Kane? Do you read, write, and speak English? Are you a United States citizen? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeffrey White. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered? Is there anything about this paperwork today that you've read and signed and reviewed with Mr. White that you do not understand? Mr. White, do you believe your client to be competent? And you've explained to her legal and constitutional rights? It appears that Ms. Kane was, what was Ms. Kane originally charged with? Second degree? But the proposed plea agreement is for a lesser included Class B misdemeanor of terroristic threat, causes fear or imminent serious bodily injury. Is that correct?
Yes.
Right. The range of punishment for a Class B misdemeanor, Ms. Kane, is confinement in the county jail not to exceed 180 days and a fine not to exceed $2,000. Do you understand that? What that means is that any sentence handed down by this court or a jury on a Class B misdemeanor must fit within 0 days to 180 days. It appears that the plea agreement in this case is that you're going to plead guilty to that offense in exchange for the state's recommendation of a sentence of 2 days in the county jail with credit for time served, a $1,500 fine, with the state rejecting a few unfiled misdemeanor cases. In addition, you'll have a $270 court cost and a $35 reimbursement fee. You understand that? That's your understanding of the plea agreement as well, Mr. White?
Yes, Your Honor.
All right, Ms. Kane, then to the charge of terroristic threat causes fear or imminent serious bodily injury, Class B misdemeanor, how do you plead? Do you plead guilty to that charge because you are guilty of committing that offense? Has anyone threatened you or forced you or pressured you to plead guilty to this charge? All right, the state will accept Ms. Kane's plea of guilt. Mr. White, any objection to states one? States one is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Other than the victim impact statement, anything further from the state?
Judge, I would note for the court's information, the reason for the reduction is to be, I'm going to put the air quotes, weapon used by Ms. Kane was effective. State is not that charge. But beyond that.
Okay. Mr. White, I'm gonna change this trial court certification of appeal. It's checked off that it's not a plea bargain case and the defendant has the right to appeal. But this is a plea bargain case. So Ms. Kane, you're understanding that you do not have the right to appeal in this case since it is a plea agreement and the court is following the plea agreement. You understand that? It's okay.
You can discuss that. But I actually think that I may have got the top up and top off from the last case too.
Well, I'm not sure. I'll double check that. All right, based on the evidence before the court will find that there is sufficient evidence to convict the defendant of this offense. Court does follow the plea agreement and convicts Ms. Kane of the Class B misdemeanor offense of terroristic threat, causes fear or imminent serious bodily injury. Court assesses her punishment at 2 days confinement in the county jail. Court issues her credit for 2 days' time served towards her sentence. Court orders her to pay a $1,500 fine and court cost of $270 and orders her to pay reimbursement fees of $35. Mr. White, do you know if she's prepared to pay off any of these obligations today? Thank you, Mr. White. I do appreciate that. All right, Ms. Kane, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted. After that, then you can step across the hall and pay the clerks, okay? Carl, could you assist the bailiff here? I want to check that paperwork with Mr. Woodwhite on that job. Okay. And so are we just doing a special order of commitment on?
Judge, they're just changing the conditions of probation. That's.
Well, and there's also going to need to be an order of commitment that she'll need to take with her to the jail, so they'll let her in. Because it's not in the judgment.
Yesterday.
Yeah.
I understand. I just put on one, but how was it all?
Well, there was, you had filed an answer in a report, but so had Jonathan, but the only order was Jonathan. So, but Jonathan said that there were multiple tri-county plaintiff or tri-county suits, so.
I was on another one that called up there and said, I don't need paperwork like this. I don't know what you're talking about.
Yeah.
They told me, no, that's my mistake.
Yeah, yeah. I'm glad he did. Have you had any update with the DA's office? What's up? How'd you call him and say, bring him up?
Yeah.
You may.
So we're right. I think that paperwork issue should be related to the,
But we don't know which way.
I do. Should put it on the chamber. Here things that are.
She signs it first, and then she signs it.
No, so I think all we need is that order of commitment, right? Okay. They have it all over there. It's on one of those. Yeah, that's fine. What's her name? Miss Munn. If you'll come forward, we're gonna go ahead and print you and do all that while we're waiting. So I don't need this. I don't know if you want that. It's that victim impact statement.
Yes, sir. Did you sign it?
Mhm. Okay, we have a update on Raina.
Yes, Judge. My victim's assistant.
Yes, we'll be on record. This is, let me go over here. This is CR 2132. Mr. Raina, if you're in here, if you'll come onto the podium, please. This is in regards to defendant's request to have conditions 4 and 5 lifted from the pretrial release. Go ahead.
Judge, my victim's assistance coordinator reached out to the victim, alleged victim in this case. She does want to lift the no contact. She is pregnant. She's on bed rest, and she would like Mr. Rainey's assistance in those things. They are attempting to reconcile. State would, yes, stand on its objection, but obviously make that information its decision and check away the sentence.
Mr. Raina, I don't want you to say anything, okay? But I'm going to tell you that I'm going to lift conditions 4 and 5. All right, my judgment tells me not to, because it's there for a reason, right? If you've got a problem with violence, especially with violence against women, especially with violence against women that you're in a relationship with, or that are the mother of your children or your wife or whatever she is, a judgment tells me not to do that. But based on the information that she's provided, I'm going to do it on her request, not on your request. But I'm telling you, if I smell anything that does not smell right with this situation, if she calls in, if there's another call out, and I'm going to ask the probation department to check up on this, if there's any problem whatsoever, if you so much as raise your voice the wrong way, I'm going to find your bond insufficient. I'm going to put you back in jail. Okay? So I will lift conditions 4 and 5 on the conditions of pretrial release for Mr. Raina, and I'll sign those today. Do you have those?
Yes.
Okay. So you're free to be around her with my admonishments to you. You understand? All right, we'll get signed copies amended, but based on my order today, you're free to go. Yes, thank you, Mr. Raina. Is this all her time though? I think she's got 8 days. Is this 8 days?
I believe she has 2 days credit and then she's gonna serve it.
So that'd be 1, 2. So she's getting 4. She's getting 4 each one.
4 each weekend. So she stays in through Monday.
All right. And have I pronounced sentence on her? Is she still here or has she been? And we fingerprinted her. I think I just want to make sure I did everything I was supposed to do. And just make sure your client knows that if she doesn't, is she still here? Is she still in the bank? All right, just make sure she knows that if she doesn't report, it's going to be considered a violation of the community supervision.
Assault case that exists out here, sheriff's threatening and told you it's a meeting, so it's really good. Christmas story and start saying that.
Put your eye out. Well, you and I had that case when I was DA where you had a guy that shot a kid or something like that with a high-powered BB gun, right? Shot him in the eye or something like that. And we argued for days back there that it's a deadly weapon or whatever. But hey. I know I did. All right, so it's just Mr. Denny's court costs, right? We don't have it straightened out in about 2 minutes, because otherwise I'm about to call time of death and say, come back at.
Yeah, I'm not really sure. I would check downstairs. Yeah, I'm not really sure.
You're not on the jail docket, are you?
Yeah.
Are you seeing any jail clients over there today?
They're not just Wilson on the case, so. just
I
trying
tell you
to-
what, Mr. Sanders, if you want, it'd be in your best interest, go check on it real quick and let me know. If we're not gonna have it done in the next 5 minutes, then we're just gonna come back at 1:30. Is Mr. Rain is still here? Mr. What else? Okay, you gonna have him sign? Yes, that's right. Thanks, sir. Do me a favor, will you get me an order finding bond and or bail insufficient on Melanie McCreary? You know that form that's usually, it's got 2 little check boxes. It's usually what I do when people violate the pretrial release. I think on this McCreary, since she's in custody in Coffee County, I'm just gonna go ahead and find her bond insufficient. We'll put a hold on her and just pick her up in custody rather than resetting to see if she gets out.
I'm taking her back. We can go call around Thursday. So when is it you're gonna go to first? What? It's, sorry. Your conversation. Hair drugs and my face.
Drugs.
What?
I'm gonna try to get an appointment in June. I actually, on today, get an appointment in June, give me time to,
Yeah.
I hope it's gonna be fine this week, and when I did, she said, "We appreciate your proactivity, but it's too far in advance." So she's gonna call me back in about 2 weeks, then see what their schedule is like, it's on maybe June. That's a very long answer to a very short question.
So that's too far.
Her schedule.
So I just want, like, from week to week. I say, next week.
Is it possible? Well, no, because when I schedule I think do this, I think that the other thing was that we got the amounts figured out, 76 in court costs, and so the state was gonna do a fine of 424. I think the holdup back there is they're trying to get the bill cost situated, which I told them that we weren't worried about that because he's planning to pay it all.
So everything else is going on this.
So, yeah, I guess we just need to mark out where the fine amount is 500. And then I guess on the plea admonishment page, we should change that to the fine fee.
Here, I'm gonna let you and stay. Y'all mark it out where it needs to be. Here. Put that with it. And so I'm not gonna set this. I'm just gonna put the warrant on there. All right, Mr. Howell. All right, let me see where we were in this process. Where did we leave off, Ms. Christian, do you know? I know Mr. Howell, I swore you in. You understand you're still under oath. I believe as I was reviewing the plea agreement, I asked about the court costs. So the plea agreement in this case is that you're going to plead guilty to a lesser included Class C misdemeanor of assault. Assault causes family violence, Class C. For punishment of a fine of $424 with $76 court costs and being ordered to reimburse Van Zandt County $750. Is that your understanding of the plea agreement? That's what you're asking the court to approve today? All right, so Mr. Howell, to the Class C misdemeanor charge of assault, family violence, how do you plead? You're pleading guilty? And are you pleading guilty because you are guilty of committing that offense? Has anyone threatened you, forced you, or pressured you to plead guilty to this offense? All right, court will accept the defendant's plea of guilt. Mr. Sanders, any objection to states one?
No.
All right, states one is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Is there a victim impact statement or a victim position on the plea agreement in this case?
Judge, we reached out, the victim is currently incarcerated.
Thank you, Mr. White. All right, based on the course review of the evidence, I do find that there's sufficient evidence to convict Mr. Howell of the Class C misdemeanor offense of assault causes family violence. Court makes that finding and assesses punishment for Mr. Howell at a fine of $424, court costs of $76, and orders reimbursement fees of $750. Mr. Sanders, is your client making any of those payments today?
Yes, sir. We paid $5.
And what is he going to do with regards to the $750 reimbursement fee?
Judge, we'll say,
If it's all the same to you, Mr. Sanders, I would prefer that the $500 be paid towards attorney fees rather than court costs and fine at this time. As that's money that's expended to you directly from the taxpayer account, whereas the court cost is divided up between us and the state. All right, Mr. Howell, Court hereby remains you to the custody of the Van Zandt County Sheriff so we can carry out terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted and then ask that you step across and make a payment towards your court costs.
We'll get them back on Thursday.
Sure, yeah, I'll work on the squad. I can work on this afternoon during the jail docket when they're bringing people up. Mr. Howell, when you make that payment, just tell them that you want to pay that towards your attorney fees. All right, and then after that, I'm going to give you a card. You need to make contact with Ms. LaPrade here to make a payment plan for your court costs and fine and the rest of the money that you want to owe on attorney fees, okay? There's her phone number on there. She's gone to lunch right now. You could call her this afternoon to set it up, okay? All right, thank you, Mr. Howell. All right, I believe that concludes this morning's docket. Court's going to stand in recess till 1:30.